Here to give his post-closing arguments analysis is none other than veteran prosecutor and BNC's legal contributor, Paul Henderson. All right, Paul. Before we get into closing arguments, let's talk about William Bryan's attorney and his latest foolery. I mean, it's hard to keep up at this point since there's something every day. He requested yet another mistrial, making this the 5th request that the court has denied, but he also filed a motion for severance. I've been struggling to understand why Goff didn't ask to have his client tried separately before the start of the trial. What sense does it make to ask a day before the jury is about to deliberate?
Well, I think, one, you get to see what the prosecution, how they're going to put in the case. And then, two, it's just yet another distraction and opportunity to focus on anything other than the facts. It's not really a surprise to me. And part of the strategy in this case, from my perspective, has been from the defense to just throw things at the wall. And that's why you're hearing all of these conversations, all of these wackadoodle motions that are all over the place that focus on anything other than the evidence and anything other than what the defendants did. They're filing motions about Ahmaud Arbery and his background. They're filing motions about pastors in the courtroom. They're filing motions about people doing peaceful protests and gatherings outside of the court. And now we're hearing a separation argument. I wouldn't be surprised if we hear more motions that are frivolous and don't speak to the evidence and don't speak to the charges, because at this point, there's very little place for them to go, and they don't lose anything by making these arguments. The reason that it's because there are 3 of them. And so it's not a mistake to me, I think, that we're hearing a lot of the racist comments and vitriolic and incendiary arguments and motions being made by Goff, and the other 2 are silent. And then they are making these passionate pleas that are separated from the racist perspective from the other motions that are all codified in the arguments being made by Goff. And so I was not surprised to hear that motion. I was disappointed to hear it, but it makes sense on why the defendants would want to be separate, given the state of the evidence and given the video, even if it's just another reason to delay what is going to happen with this jury evaluating their behavior, and if there's an opportunity to be heard separately where all of the bad behavior isn't conflated against all of them collectively. That's what's behind the motion, and that's the legal reason why you would normally make that kind of motion. But I think it was time purposely and specifically to interrupt the trial and give the judge a route to do anything other than hold them accountable with the evidence that's been presented so far to this jury.
Well, Goff also asked to have juror number 380 removed. Not coincidentally, juror number 380 happens to be the only black person on the jury. Paul, remember the prosecution accused the defense of striking all of the black prospective jurors from the pool? And remember how the judge admitted something didn't smell right, that there was intentional discrimination that was used during the strike process, but still couldn't do anything about it? Now Goff is trying to get rid of the only black juror. Do we need any more proof?
We don't need any more proof. He is making the arguments to affirm what we already know, that Goff's entire approach in this case has been racist from the beginning. And later on, I think we're probably going to talk about the arguments that were being made in closing that affirm a racist perspective. But this motion in particular could not be more blatant, could not be more offensive, and could not be more ridiculous and racist than to try and remove the singular black person that is left on the jury after the judge has already commented that it seemed racist or discriminatory in how this jury was selected in the first place. It's offensive to jurors. It's offensive to Ahmaud Arbery and his family. It's offensive to the community, specifically people of color. And it's offensive to the criminal justice system. I'm glad we're having conversations like this because I, too, like to call a thing a thing. The motion was racist, the intent was racist, and there's nothing other than to try and distract anyone and everyone from focusing on the intent from these defendants in being held accountable for murdering Ahmaud Arbery, as we all saw in that video. So that's what it is.
Well, Goff continued his criticism of black pastors and supporters of the Arbery family, claiming, get this, his client is experiencing a, quote, lynching. Paul, I know you're itching right now, but let's listen to that clip first.
Third parties are influenced in this case. They've been doing it from the gallery in this courtroom. They've been doing it outside. This is what a public lynching looks like in the 21st century, with all due respect. Just because they haven't put a gallery up, they haven't put a podium up outside with a hangman's noose on it, doesn't mean that this isn't a trial, despite the best efforts of this court. This isn't a trial that's been infected by mob violence of a woke left mob.
Go off, Paul.
Okay, so here is the thing. It could not be more racist that they are raising these issues specifically with the intent to distract the court again. Notice that they are not saying anything about the evidence. Notice they are not saying anything about the process in ways that are credible or have a legal basis at all. Instead, this is a dog whistle, both to the court and to the jury, to do anything other than hold their clients accountable in ways that, again, is beyond just offensive. It is absolutely racist. And if we have any concerns about that, and we should be able to take a step back and try and unpack what this really means and why they're trying to do it. Because again, at the heart of this is us trying to address the boundaries between both self-defense and vigilantism, which are closely tied and deeply rooted in racialized approaches that have been codified in the criminal justice system, that one, gives a preference to white people, and two, casts black people as suspicious. And I will say not just black people, other people of color and communities of color in our criminal justice system. That's what's behind it, and it's just offensive. It should be offensive. We should really be trying to unpack that with advocacy intent to make sure that we are trying to make changes at a local, state, and national level to address behavior exactly like this. It could not be clearer. This is an objective analysis about something that should be offensive to everyone.
All right, now to those closing arguments, Paul. We've got a few minutes left, and I want to get to the prosecution, since they do have the burden of proof, the burden of proving this case. So here's lead prosecutor Linda Dunikowski.
All three of these defendants made assumptions about what was going on that day, and they made their decision to attack Ahmaud Arbery in their driveways because he was a black man running down the street. You don't get to say I was acting in self-defense, and there's three of them, and it's the law. This isn't just something made up. There's three of them in the law, okay? If you are the initial unjustified aggressor, you don't get to claim self-defense. If you're committing a felony against somebody, you don't get to claim self-defense. And the third one is if you provoke somebody so that they defend themselves against you, and then you go, oh, look, he attacked me first. But you really were the one who was provoking the attack on yourself. You don't get to claim self-defense. And that's the law.
Paul, that argument is a familiar one. It was made in the Kyle Rittenhouse trial. It clearly didn't work to convince the jury in that case, but will it work in this one?
I mean, it's hard to read the tea leaves because juries do things that are unexpected all the time. You know, I was surprised in Trayvon Martin. I've been surprised in numerous other cases that don't get national attention. And I could be surprised again. She's arguing the right things. I watch these trials like you do, like it's sports, and I scream at the TV, I yell out objections, I clap for people. But let me tell you, I thought she meant that she was making specifically and trying to undermine the self-defense approach that defense counsel is trying to sell to this jury was targeted and specific. It really just depends on how the jury is interpreting this evidence, because remember, there is a singular video that tells everyone exactly what happened, but there are two very different interpretations of that video of what's happening and how it relates to the law. And that's why we're going to continue to see arguments on both sides. Hopefully that gets us to a jury of guilty verdict.
All right, Paul, stay with me because we've got more to discuss on today's closing arguments after this short break. After 10 days and more than 20 witnesses, attorneys in the murder trial of Gregory McMichael, Travis McMichael, and William Bryan made their case for the last time in today's closing arguments. Here to continue the discussion and help bring you up to speed, veteran prosecutor Paul Henderson. All right, Paul, before the break, we listened to the prosecution talk about how the defendants in this case were the initial unjustified aggressors, and you don't get to claim self-defense, that if you're committing a felony against somebody, you don't get to claim self-defense. And lastly, if you provoke somebody so that they defend themselves against you, and then you go, oh, look, he attacked me first, but you were really the one who was provoking the attack on yourself, you don't get to claim self-defense. Here is how Jason Sheffield, the attorney representing Travis McMichael, how he responded in his closing.
Duty and responsibility and following the law will always be intertwined with heartache and tragedy. An aggravated assault, by the way, is a felony that can be committed by the use of fists.
He says that his client had a duty and responsibility. None of these defendants, Paul, were police officers on February 23rd of 2020. When you have zero authority to stop someone, and when you try to stop them by chasing them down with your truck, you're gonna get some resistance in whatever form. So now you fear that that resistance could seriously hurt or kill you?
That's exactly it. And just like you said, because that's what vigilantism is. It's acting on behalf of law enforcement without authority. And so as they try to conflate these ideas about what law enforcement is and should be, as interpreted by their clients, the defendant, that's the disconnect. I think that's where the fault is. And they fought so hard. And if you listen carefully to their statements, they kept trying to use these esoteric law enforcement terminologies to describe what their client was doing because they want him to have a mask of law enforcement. Now, this is before we start talking about the faults of law enforcement in this case specifically, but we just focus on the defendants and what he did as he tried to interpret what he believed law enforcement would do, what law enforcement could do, and that by definition that he was acting on their behalf to execute. Pun intended. That's the problem because the facts don't support it, and it was wrong, and it was offensive. And this is before we start talking about the race and the suspicion and the fears associated with Ahmaud Arbery inappropriately that led to his lynching and his murder. I said what I said.
All right, Paul, you did. Paul, let's take a listen to the second closing argument given by Greg McMichael's attorney, Laura Hogue.
Turning Ahmaud Arbery into a victim after the choices that he made does not reflect the reality of what brought Ahmaud Arbery to Satilla Shores in his khaki shorts with no socks to cover his long, dirty toenails.
This one right here, Paul, this one really made me angry. This is who I would be addressing in my rebuttal tomorrow. Before I get to the merits of her weak argument, how dare she talk about someone who didn't deserve to die that way? Even if everything they accuse Ahmaud of doing was true, he deserved to have an opportunity to be judged in a courtroom like those three. What purpose did mentioning dirty toenails have for her overall argument other than to upset and offend Ahmaud's family, which I'm told it did? She was unprofessional, disgusting, and it was cheap.
I love that you had the same response that I did audibly and yelled out at the TV, how dare you, just like you started off this conversation. And to me, if you're listening, did you hear when she said that and someone in the courtroom gasped and said, wow? I like that that was the response because that was my response too. I hope the jury is paying attention to that. I hope the jury is listening to that and that they heard that and they had an internal response as well, because it's beyond just offensive on so many levels. And they have constantly, from the very beginning of this case, tried to paint Ahmaud Arbery as not a victim, but as a suspect. And I can't tell you how many times I stopped counting in their closing when they talked about him and called him a suspect over and over and over again, trying to conflate his presence there as being more than just a black person. At one point in the defense attorney's closings, They talked about how the neighborhood was changing and there were suspicious people, and that was Ahmaud. And that's a dog whistle for people to understand that they need to be vigilant against, and this is a quote, people who have no lawful reason to be there in that neighborhood. Now, we don't have to guess as to what that means, because that means Black people. And this is why standing up for Ahmaud Arbery is standing up for other communities of color and racism in this country. That is exactly what the argument means. She talks about Ahmaud Arbery and denigrates him, denigrates his presence there in the neighborhood, denigrates his status as a victim, specifically to lead the jury away from focusing on the behavior of the defendants, which is what we're in this courtroom to do, to hold them accountable for what they did, not how that could be justified because Ahmaud Arbery, they were afraid of him for unjustified reasons. It's beyond offensive, as we've already said. It was purely, intentionally, and specifically racist. There's no other way to listen to it. There's no other way to evaluate it other than to hold the defendants accountable for murder.
All right, and finally to the last closing given by Kevin Goff's William Bryan's attorney. Take a listen.
I would submit to you that you can call it karma, you can call it fate, I would call it divine providence. Somebody is guiding Mr. Bryan, whether it's a conscious thought process or not. Something is guiding Mr. Bryan down this street to document what's going on.
Paul, he did it again. He called his client's involvement in Arbery's killing fate or a divine providence. He was right about one thing, though, that there would be no trial but for his client's recording. But please, please don't insult the intelligence of the jury by implying that William Bryan made such a recording for the greater good.
That's correct. And I think that he raised it because he wanted to kind of subtly separate what his client's role was in this whole process, although he was just as much a part of it as the other defendants. He also said that this was karma, as if these were positive things that what his client was doing in recording. And again, this is why all of the defendants are being tried collectively and together, because they acted collectively and together. And they acted collectively together on racist motivations, which led to this killing. And so talking about it with a different lens, and remember, we've all seen the video, as have all of the advocates and the attorneys in this room, but their lens of seeing that video, of trying to paint their clients in a positive light, is an uphill battle. And that's why they keep trying to distract the jury, trying to distract the prosecution, and trying to distract the judge from evaluating the specific behavior of what they did, which is hunt down Ahmaud Arbery in the street and kill him by shooting him. That's what happened. That's what's on the video. We know that's what happened, and everything else is just a distraction. And in this case, they happen to be racist distractions as well, without legal bounds and without legal authority, in my opinion.
All right, Paul, the conversation is going to continue after this short break, so everybody please stay with us. Welcome back to Making the Case. Veteran prosecutor Paul Henderson is still with me. Paul, let's talk about the timing of this trial. We're 3 days away from Thanksgiving, and the jury starts deliberating tomorrow. I'm not a betting woman, but I would put my money on them reaching a verdict before Thursday. No juror wants to have this hanging over their heads during the holiday, knowing they have to come back to court the following week to deliberate. Now, the court could call a recess until next Monday, but then you run the risk of jurors having the time to research the case, discuss it with loved ones, or consume media coverage. I don't have the answer, but either way, is it unfair for the defendants?
No, it is not. It is not unfair for the defendant. You get what you get. This is when your trial is coming. This is when it is your time to be held accountable for what happened. And by the way, since we're talking about timing, let's really talk about timing, because this was an offense that took place before George Floyd, 3 months before George Floyd. Were it not for the inconsistencies and the bad treatment and misconduct from our criminal justice system and law enforcement officials in the first place, this trial should have preceded the George Floyd case, but it did not because of the delay. And so I don't care about the defendants caring about what happens to them for this holiday season, because part of why it was delayed was because of their misconduct and the misconduct associated with the criminal justice system, which is not a part of this case, but has been a constant distraction and has always loomed in the background of analyzing and interpreting what happened to Ahmaud Arbery. That is a real problem for a later date for us to continue to advocate for and about, because people need to understand why there were the delays in this case, why law enforcement showed up and didn't offer help to Ahmaud Arbery, who was not dead, but instead listened to and supported the defendants in this case who are acting on proxy for law enforcement in a way that was biased. And the bias by proxy is a real issue. So yes, there is an issue associated with the jury going home, and that's a hard problem to have, especially when we're talking about, of course, at Thanksgiving, people are going to be surrounded by their family and friends, presuming they aren't sequestered and can interact with people. And this is going to be the topic and the conversation that is likely to come up. How could it not, if people know that their family and friends are on this jury? And that's got to be hard for anyone. And you are correct. At this point, they've heard so much of the evidence and have formulated an opinion about this case. They probably are very ready to give their decision and vote in this case. And again, it's not lost on me is that the tape was shown that showed the entirety of the crime. And we're really just arguing back and forth in this trial about two present sense impressions that are very different interpreting that tape. But the jurors at this time should have an opinion about it, even though all of the evidence has not come in, or it has, but the argument has not finished coming in, and they haven't been given their instructions by the judge yet. But I would imagine that if they can get that to them sooner rather than later, that they could come to a conclusion very quickly. I know that I could.
Paul, the prosecution is going to give their rebuttal tomorrow morning, so they have a whole night to think about what they're going to address, what they're going to say. What parts of the defense's closing, I mean, they weren't good overall, but what parts would you have the prosecutor focus on and address?
Oh, you're asking the right questions, because I already wrote out the closing for them. Now, I would focus in line item, outline all of those statements. Remember from opening arguments when defense attorneys were all over the place, making all kinds of claims. Here are some of the things that they said. That the defendants had probable cause to believe that Ahmaud Arbery had committed a felony. They said that the defendants had a duty to protect the property of Larry English, the neighbor who they had not confirmed had had any crimes committed against them or that Ahmaud Arbery had done it. They also said that Ahmaud Arbery, they pointed their gun at him, trying to de-escalate the situation by pointing a gun at him as based on law enforcement training. All of these things I would have outlined up to dissect and to present to the jury about what defense had promised them about these defendants that are sitting there and why these were wrong interpretations of the law as based on the facts and the evidence that they had seen. And I would outline all of the argumentative things that defense counsel had said and all of the racist things that defense counsel has said to shine the light on it, to make sure that the jury knew going into that room that defense counsel had been wrong in their interpretation of the evidence and tried to twist the interpretation of the evidence by having an adoptive admission through the lens of a law enforcement approach, which was wrong, in order to try and justify their clients collectively their behavior. That's what I would do. And I'm hoping that the prosecution will do those things. I'm waiting to hear those points be made as part of the closing.
BNC's legal contributor and veteran prosecutor Paul Henderson, as always, thank you so much for sharing your expertise with us tonight. Thank you, my friend.